Select Committee on Transport, Public Works and Infrastructure, and Public Service Administration is dealing with the amendment to the Civil Aviation Act, and that is sponsored by the Department of Transport. Having had an opportunity to sit on the matter in the last two meetings, we then invited members of the public to engage with the bill, and as a result thereof, today we are having the benefit of receiving a presentation from those that made comments, and indeed in terms of the agenda that is tabled before us, we will then formally ask the committee secretary to present the apologies to the meeting. Over to you, Trubega.
Thank you, Chairperson. As I've already alluded, we have received two apologies from Honorable Matebula. She's traveling to Cape Town. Apology number 2 is for Honorable Mama Rakani. She's attending a joint standing committee meeting. And then apology number 3 is for Honorable Moshodi. She's going to leave at 12. She's got a meeting with the Chief Whip of the.
Thank you. Do we have any from the political office of the department, the ministry? Having said that, let's then agree that those are the apologies that we have received, and we will then get an opportunity to go through the agenda just to sensitize the participants in terms of how our meeting will be structured. We will have oral submission by Mr. Van Zyl from the Independent Aviation Consultant, and also Mr. Herman Verdenboer from the Legal Aviation Consultant. I hope my pronouncement is correct. Then the third submission will be from Mr. Keith Story, the CEO of the Commercial Aviation Association of Southern Africa. Then it will be the response by the Department of Transport to the oral submission. And then we will then get the responses by the parliamentary legal advisor, the state law advisor to the oral and written submission. Then it will be questions and answers and then deliberations and the minutes. I wanted to propose that with the minutes, we share them to the next meeting together for the purpose of the reasons that were advanced last week for the purpose of the postponement of the item. Having said that, let us just, we have our legal advisors today in the meeting. Do we have our legal advisors together?
Chairperson, I saw Mr. Jenkins, Advocate Jenkins, logged in. I'm not sure.
Yeah, I'm here, Chair. I'm here.
Thank you.
If I go down there, I'm completely in the meeting. Thank you, Chair. I'm here.
100% you are correct. We are happy with that. Let us then, without any waste of time, then allow the first submission. Mr. Van Zyl, the floor is yours.
Good morning, Mr. Chair. Good morning.
Good morning, Mr. Van Zyl.
Thank you very much, Mr. Chairman. Thank you for the opportunity to address you. You may well ask, why do I go to the trouble of being persistent and making comments on this particular bill? The reality is I've dealt with legislation first in 1990 when we changed the legislation in terms of air service licensing in South Africa. Thereafter, the creation of ATNS, AXA, the Civil Aviation Authority Act in 1998. And then finally, I was involved with the original Civil Aviation Act 2009. So I have a very pertinent interest in the matter. And if I may say so, I believe, and if I could go to my presentation now at this time, that if the host can just enable participant screen sharing for me, then I would like to just continue with some comments. The main emphasis being, Mr. Chairman, is that we need to have a realistic and workable Civil Aviation Act for the next 10 years. We only seem to be able to get a change in the Act every 10 years. So whatever is endorsed by your committee will be what the aviation industry will have to work with and abide by in the next 10 years. So the emphasis is, if I look at from your website, the slide on the right-hand side, the emphasis is that you have an oversight function. And that really calls for openness and participation. And hence my involvement really is I would like to bring my share to ensure that you are fully informed to make an informed decision as far as the proceedings of this bill is involved. So I'd just like to touch on a few things. I'm not going to go into detail in the slides. I've made the submission to you in that regard. But the first thing I need to stress, Mr. Chairman, is on the background to the memorandum. There the statement says, yes, that...
My apology, Mr. Van Sail, we have requested to be given an opportunity to share the document. Let's just check as to whether either Enrico or Hlupeka have done that, so that as you engage, you have the document flooded.
Right. Can I start and show? Okay, I started screen sharing.
Right.
So
right.
if I can just enable, yes, there it is. You have the slides now?
Yes, indeed. You can proceed.
If I was just activate my site now, because it's, yes, are you unable to follow?
Yes, we are following.
Thank
the
you.
screen.
Right, the first thing I want to touch on, Mr. Chairman, and your committee members, is the description of the background and purpose in the memorandum. What has to be understood very clearly is in 2009, ASIP, the Aviation Safety Investigation Board, was established. The only issue is the Department of Transport never staffed that entity. And the real reason is that they could not obtain the funding from Treasury. As I understood it, Treasury said, you want to create ASIP, you find the money within your allocated budget. And from 2011, 2010, when the Act was really promulgated, there's been no attempt to staff ASIP. So the issue to say is, but practical aspects is not quite correct. It's really a clear statement on an issue of funding. And unless there is a commitment from the department this time around to staff ASIP, then we're really wasting our time in making all the amendments to the Act. And finally, on that aspect, we need to make sure that as ASIP has existed as the South African Civil Aviation Authority, I believe there's wording that needs to be added to state a juristic person known as the Aviation Safety Investigation Board, established by Section 10 of the Civil Aviation Act, shall be deemed to have been established in terms by this Act. So this is something I think that the committee needs to consider and that the legal advisors should give attention to. As far as the issue is on the definitions, Mr. Chairman, this is, I found this to be quite surprising. I can't help but tend to think that the definition of an air service has been slipped in since the last portfolio committee meeting. Because the issue really comes is there's significant changes now to this definition, and it have sequential impact on the Air Services Licensing Act. And the big challenge comes in with the deletion of the exemptions. Now, if that exemptions are deleted, that basically means an air service is basically every flight that takes place in South Africa where there's a passenger involved really requires an air service air operating certificate. Now, I don't think that's been an intent here. I really need to stress to the legal advisors, I believe this is a major conflict, and you really should retain the original definition of the Air Services Act of 115. Because the big challenge comes in, and I note in the bill as well, there's no mention of subsequent amendment to the Air Services Licensing Act. With a change of the definition of air service, one would have now expected that will have to be carried over into the Air Services Licensing Act. So that needs attention, Mr. Chairman. Mr. Chairman, then my old pet one as well is the issue of changes from the wording of director to that of commissioner. It's really, as I've said here, many parts of the world, the CIAs are headed by a director, even a director general, which is probably a better description, because a commissioner, you have the same equivalence as to a commissioner of oath, for example. So I really don't think there's any need to change that wording from director to that of a commissioner. And the emphasis I find here as well is that the issue of the cost implication of changes of that word should not be underestimated. I was surprised to note in the Portfolio Committee response in February that the department said, yes, there is no cost to the department, which is fine. They just changed the wording. But they are silent on what happens to the industry. There's all those rewriting of manuals, software programming, licenses, all of that in which the wording has to be changed in the future. So I really believe that that is something that needs the attention from you as a committee. Other aspect, Mr. Chairman, is the issue of aerodrome versus airport. An aerodrome, as is shown in the right top corner there, that is where you just normally have a runway, an airstrip, nothing else. Windsock and the runways there, that's an aerodrome, that qualifies as an aerodrome. Once you start adding facilities to that, to process passengers, freight or mail, then it becomes an airport. And here we need to have a clear understanding.
My apology again, Mr. Fansay. The person that is driving the sharing is just stuck on the first slide. Is it you, Enrico, that is in charge, or is it Mr. Fansay? Because it means you must be able to run with the screen, Mr. Fansay. If you are the
Mr. Fansay.
Right,
Okay.
sorry, I'll end this show and I'll start it again on sharing. Is that acceptable to you?
Yeah, now you can move now.
Can you see it now?
Yes.
And if I proceed?
Yes, you can proceed.
Now my computer has
Through the chair,
it's
if I
frozen.
may ask a question. I do not think Mr. Van Zyl is presenting. I think it is somebody inside the committee that is actually presenting the slides. Maybe he could actually share his. That is where the glitch is. Sorry to intervene. Thank you.
All right. Let's then agree. Chupeka or Enrico, can you address that?
Right, can I try again?
Yes, but now the screen is off now. I mean, the presentation is off the screen.
Oh boy. Okay, I'm trying again. I'm sorry about this, Mr. Chairman. I don't know where the hitch is coming from.
Yes, there you are.
Have you got it now?
Yes.
Okay. I'm just going to proceed to where I was previously.
Great.
Now is on the air service issue. And then the commissioner position, Mr. Chairman. I do believe that there must be clear indication to you as what the cost to the industry will be. That's something that needs to be kept in mind in dealing with amendments to acts and regulations and what the impact there is on the industry. On the definition of aerodrome and airports, Mr. Chairman, there's a need for the department to make a clear distinction. What do they really want to regulate? Is it that aerodrome, that strip, or is it a fully developed airport with facilities, with terminals, with passengers, with immigration, customs, etc.? So that needs to be finalized with the department. They need to make up their mind. Are they dealing with aerodromes? Are they dealing with airports? What do they want to do? So that I'll leave it at that stage, Mr. Chairman. The next aspect, Mr. Chairman, that is really of consideration to us is the executive responsible for aircraft accident incident investigation. And the question there is if that person is appointed by the CAA and not by ASIP. ASIP is really out of the control. And we've seen already if a person is appointed by the CAA and the CAA is criticized in a report by that, then the executive is in a difficult position. And we've now seen it's been highlighted with that accident of the Civil Aviation Authority's aircraft, in which there's now a conflict between the current director of civil aviation and the executive manager whose appointment was not renewed. And his emphasis was that his appointment was not renewed because he criticized the CAA. It is a difficult situation. And that I really believe the executive responsible for that investigation must be an employee of the ASIP and appointed by ASIP and reporting to ASIP, because otherwise you will have that conflict of it. And it's going to be very interesting once this report is released on this accident, how the situation developed here, how the issue comes about of the oversight of the CAA with itself. So there is serious conflicts there, Mr. Chairman, that I do believe needs to be given attention to. Now, I know I've seen the response from the South African Air Force on it. Can I just confirm you're still able to see my slides?
Yes, we are. We are on your slide.
Thank you. So the big problem there comes in, Mr. Chairman. If there is a collision between a military aircraft and a civil aircraft, and there were arms being carried as with things like this, this is where the things are going to get very difficult. And I can speak of experience. We have had collisions between military and civilian aircraft. And the big issue is I still believe that matter is not very clear with the written permission. That aspect, I do believe the legal advisors must have a very good look at in that regard. Now, Mr. Chairman, on section, what is this issue of reporting? I think if we look at the Act right now, it basically says that the report must be submitted to the Minister, Parliament, and public. But the issue is who is responsible to take action? Who is accountable for what happens? What is to correct it? The purpose of an accident investigation is to identify what went wrong so you can fix it, so you can take steps to it. And so it's very, very unclear how that issue comes about. I do believe that ASIP clearly should, as ICAO says, that the investigation authority should not report to the same minister responsible for the regulation or safety oversight of civil aviation. I would rather prefer that to be responsible to the presidency or to another minister. There needs to be check and balances in this aspect. I'll leave it with that for you to consider in that regard. Now, appointment of members of ASIP, and I think that was where some of the big problems in the past came about. The appointment requirements, experience requirements were very strict, and now it is changed, and there is a reference to say that the members must have other relevant expertise or qualifications. Big challenge comes in, how is this to be assessed by whom to decide what is relevant in that respect? So this needs to be given some more attention in that regard. So I believe that that needs to be dealt with, as well as how the financial aspects of ASIP is going to be controlled. Should there be involvement of the Minister of Finance in that respect? Because an accident investigation can be extremely expensive. I recall that with the World Cup, my advice to the Director of Civil Aviation at that time was that if there's an accident and an airplane is in the water at either Cape Town, Durban, or Port Elizabeth, I will be coming to him and asking for 2 billion rand to investigate that accident. So this is very expensive aspects, how the financial aspects of ASIP needs to be handled. So we need to take that in mind, please, Mr. Chairman. There's other issues, and all those is because of past experience I had. How is an owner entitled to damages? I believe this is aspects that that the state legal advisor should be clear with you. What is the involvement of the Department of Finance in that respect? And then, of course, Mr. Chairman, influences on the Director of Civil Aviation, the head of the CAA. Now, I believe that wording in the clause should be there, attempting to influence the commissioner. That should be added. I do believe that is relevant to that aspect. Section 99, I have serious concerns on. The expansion of the limitation of liability is really too wide. It really puts the CAA above the rule of law. I think the emphasis here again should remain restricted to the employees of the CAA, because otherwise you have a situation that the CAA is just can do whatever it wants and claim to have done it in good faith, and it's really not. That limitation should only be to the employees. That is that exemption is far too wide. And then monitoring of regulatory compliance, the issue of whether a warrant is applicable or not, that must be clearly defined in the legislation. Other issue, the issue of exemptions, Mr. Chairman. The exemptions is a reality in aviation industry. You cannot at all times on a specific day be in compliance with an aspect. For example, a part may not be available from the manufacturer, and then you have to have an exemption or an extension for the compliance period, taking in mind the risk factors, etc., involved with it. And to have this exemption, the minister to make the decisions on exemptions is not practical. His office will be swamped. And it really must remain with the director. It's mainly about the regulations that the exemptions is about. But to take it into the minister's office, we'll end up with a situation similar to what we have with the firearms licensing. It just becomes impossible to handle. So really something that needs to be considered. I would not endorse and recommend for you to endorse that to be dealt with at the minister's level. Authorized officers and persons, Mr. Chairman, again, legal advisors must clearly define what there is, because there's very distinct whether you're dealing with safety aspects and with security aspects. that is in the aircraft operations and where you're dealing with airports. Those things need attention to be given to further. Fine. The other aspect, Mr. Chairman, which I'm serious concern with, is the deletion of that paragraph 3, that access to information. Mr. Chairman, documentation is very expensive today. Not everything is online. And there's that emphasis of that there must be, to ensure that whatever is submitted is in the interest of South Africa and serves the aviation industry, to ensure that we have a growing and effective industry that serves the peoples of South Africa. Mr. Chairman, thank you very much again to you and your committee members and to the Secretariat staff for the opportunity to have addressed you on this matter. As I said, I just have a personal interest in this, hence my persistence in making comments to the various committees. Thank you very much, Mr. Chairman.
Thank you, Mr. Van Zyl, for the presentation to the committee. I was informed that there is an apology that was raised around the presenter that must go to the doctor at 11. So I just wanted to check whether is it Mr. Wadenboer? Is he the one that was raising an issue of an apology? Can you just confirm that?
Yes. Thank you, Mr. Chairperson. I trust you. You have a copy of my presentation.
Yeah, just be patient a bit. I just wanted to ascertain that so that I then make a humble appeal to the members to say the engagement that they wanted to raise with regard to the presentation by Mr. Van Zyl. Can they just pack them so that we allow you to make a presentation so that we do not interfere also with your doctor's appointment? I want to believe that this is a humane platform, so therefore they will have an understanding to allow you to not to miss the doctor's appointment. You are comfortable with that, honorable members? You can proceed, Mr. Wadenboer. The floor is yours.
Thank you, Mr. Chair. Once again, thank you for the opportunity of addressing the NCOP on this particular issue, which lies dear to my heart. I've been involved in aviation for the last 30 years, so I hope I can make a useful contribution to the proposed amendment of the draft Civil Aviation Amendment Bill. Thank you, sir. I'm ready to start with my slide. Then I'll go to slide 1. That is the definitions. Okay, can I just see my, yeah. The first is the word aerodrome. It would seem that the word aerodrome is to replace the word airport in the Act, as appears from certain sections in the draft bill that has been amended. However, the problem is in a number of sections not being amended, the word airport still remains, as appears from inter alia the following sections of the Act, namely, I've given the numbers to you, sections 134, 139, and a number in section 155. The problem is you have to, if you use aerodrome instead of airport, then you have to delete airport in the whole Act as such, unless there's specific reason for keeping airport vis-a-vis aerodrome. I don't think there's such a need, but I think that the committee should just check if to make certain that aerodrome is to be used in the whole Act instead of airport. So I'm just drawing the committee's attention to this particular section as such. The second definition, heliport, as the word heliport is being included in the definition of the word aerodrome in the draft bill, it can be deleted to the Act. However, in section 139 of the Act, the word heliport has not been deleted. What is important, as the word heliport is used in part 139 of Civil Aviation Regulations, in subpart 2, there's a whole section on heliports as such. The word heliport must remain in part 139 of the regulations. It relates to the requirements and provisions regarding heliports. The definition, therefore, of heliport has to remain in part 1 of the said regulations. Thank you. That's my section 1. That's my first slide. Then what's important, as I say, my colleague, Mr. Rini van Zyl, has already addressed a number of issues that I've also mentioned in my submission. So I'm not going to labor the point. I just want again to point out that the definition of the expression air service must be looked again. The third one is a very important definition. Definition: executive responsible for the investigation of aircraft accidents and incidents does not appear in Chapter 4 of the Act. And if you look closely at the Act, the functions of the executive is limited to the appointment and management of investigators. And as I say, that can't be the whole function of the executive manager, because his role cannot be limited to non-operational matters. He should be able to give guidance and give advice to all types of investigations and issues. So I don't think the executive's role must be spelled out exactly in this act, in the section, in the definition section. What is his functions as such? What's the important thing that bothers me in this regard is, if you look at my last paragraph, last bullet, it has to be noted that the functions and powers of the ASAB, as set out in clauses 28 and 29 of the bill, basically corresponds to the functions and powers of the executive, which has to be rectified. So there has to be a distinction between the powers of the ASAB and of the powers of the executive manager as such. I think that's a very important point, which I implore the committee to have a close look at. Thank you. That's the next one is very important one also is it regards the period of 4 months notice of increase in fees, charges and levies to be industry appears too long due to a number of factors. The problem is, as to levies, the Minister of Finance is still required to indicate to the Minister of Transport with a specific period of time that proposed increase in levies is acceptable. That also can and usually takes time. The input from the industry can also take time to consider. Should be considered necessary to accept the proposed notice period due to international considerations, the COCA procedure has to be revisited. Because at the moment, as you know, in short, any proposed amendment has to be submitted to CARCOM, which publishes for comment, and then after comment, after comments are received, CARCOM has to look at the proposed comments, and even refer it back to subcommittee on this particular issue, which takes a lot of time. In this regard, must remember that CARCOM only sits every 2 months. So if there's a slight hitch in the process of dealing with comments on fees, it's going to further make it further increase the time limits in which the amendment has to be finalized. As I say, the CARCOM procedure is of a time-consuming nature and requires a lot of steps. I've worked out it takes about, if everything goes well, it takes at least, if everything goes well, for when a proposal is sent to CARCOM to be published, commented on, reviewed, and decided on by the CARCOM members, it usually takes a minimum of 6 months. So I really think this period of 4 months thereafter, after promulgation of the said fees is too long. I think a period of a month or even 2 months is more practical as such. Thank you. This one also my colleague Mr. Van Zyl has dealt with more extensively. It's just the fact that the commissioner must also be in a position to prevent that there is an attempt on him or her to unduly influence him. I think this is an important provision, and I think it should be included in this particular clause, clause 14 of the section 76, in order to protect the director from undue influence. Thank you. That is clause 14. Next one, this is a very important one, clause 48, exemptions. My colleague Mr. Van Zyl has really touched on this issue. The important point is that the amendment proposing that exemptions from civil aviation regulations only granted by the Minister of Transport will cause unnecessary administrative holdups and delays to the detriment of the client. The administrative process currently in place pertaining to exemptions involves input of the technical divisions of the CAA and the legal division of the CAA, which have to consult on a regular basis. Any recommendation by the technical or legal divisions has to follow the administrative chain of command, which takes time. That means it's going to go from the person dealing with the issue to the manager, to the senior manager, to the general manager, and then to the director. An important problem at this stage, the technical expertise to do exemptions is situated within the CAA. Unfortunately, the DOT is only of an administrative process and can only do administrative aspects and is not in a position to deal with technical issues. They'll have to revert it back to the CAA's relevant technical departments as such. The further issue is, last bullet, as a technical and legal division of CAA are located on the same premises, it's easy for the director, commissioner, to have meetings to clarify issues that have arisen before decision is taken. It's easy for the director to have a meeting to clarify certain issues before making a decision. The problem is the office of minister is situated in Pretoria, so it'll take it's at least 50 kilometers away. It's going to delay any proposed exemption if there's a number of discussions between this face-to-face discussions between the CA and the Minister of Transport. So I think it's for practical purposes, it is better to keep the exemption process with the CA as such. Thank you. Thank you, also again. This issue is also relevant. It deals with the distinction between the functions of the authorized officers and authorized persons. Now, authorized officers are persons involved in safety issues, while authorized persons are involved in security issues. Statutory security-related powers are vested in the members of the SAPS and SNDF appointed as authorized persons by the director/commissioner. Powers of search, seizure, and arrest, which are included in the said clauses, are part of the statutory powers conferred on members of the SAPS and SANDF. Powers, functions, and duties of authorized officers and inspectors in terms of the Act are all safety-related and do not include drastic powers like seizure and arrest. My conclusion is the blurring of the distinction between these two sets are not justified, and the powers of authorized officers and inspectors should be limited to safety, and those of security and of authorized persons to security. Thank you, Mr. Chair, on this point. Okay, I'm finished. Mention has been made that for the establishment of a fees committee to deal with fees that has been proposed as an increase. The problem is A fees committee, as envisaged in the said clause, is already in existence as a subcommittee of CARCOM as per section 159 of the Act and subpart 2 of part 11 of the regulations. It also consists members of the aviation industry. The inclusion of such a specific fees committee will only lead to duplication of an already existing function. Thank you, sir. Last one, that's also an issue that my colleague Mr. Fasel has dealt with. Deletion is not justified for the following reasons. Introduction of the International Aviation Standard does not require a physical insertion of the app, of the section. The content of the appropriate CATS document cannot be set out in the applicable CATS document. It's only included by reference. And for this reason, the existing subsection 2 of the Act has to remain as it indicates the process for the issuing of the International Aviation Standard. So the standard cannot be just, does not require a physical inclusion into the CATS document such. It can only be included by reference. And for this reason, it's submitted that the existing part, section 163 should be retained as is. Thank you. That's I think that's the second last. Yeah, there's one left. Thank you, sir. There's one, I think one more. Thank you for the opportunity to make a presentation to the committee. As I say, I've been involved in aviation for a long time. I really hope, and I really hope that this might be of importance to the committee that necessitates some amendments to the proposed draft amendment bill. Again, once again, thank you, Mr. Chairman, for having me. Thank you for the assistance with the technical staff to enable me to provide you with a slide, with a PowerPoint presentation. Thanks again, once again, and good luck with your with the meeting. Thank you. Thank you.
Thank you. Thank you, Mr. Maranbuo, on behalf of on behalf of the committee. It is my pleasure to receive your presentation. We will then invite Mr. Keith Story on behalf of the Commercial Aviation Association of Southern Africa to also proceed with this presentation. Over to you, Mr. Story. I see Mr. Story has left us again. Has left us. Is it an issue of connection? Let's just give him an opportunity to come back. Can you deal with that, Shubega? You are muted. Just as he was about to take the platform, Mr. Suri left the platform. I suspect he got disconnected. Are we succeeding, Shubega?
Chairperson?
Are we succeeding to get Mr. Story?
No, and also his phone now is not going through.
His phone is not going through.
Yeah, I don't know what's going on.
let us probably then probably invite the Department of Transport, but on the proviso that when Mr. Suri comes back, he will then give we will then give him an opportunity to present on behalf of CASA. Who's presenting on behalf of Transport? Supela?
Good afternoon, Chair. Morning, Chair. My name is Elizabeth Mche, and I will be presenting on behalf of the department, Chair.
Thank you, Mr. Chair. The floor is yours. We were supposed to receive Mr. Story just as he was about to take the podium. He got disconnected, so we then said, let us take the Department of Transport to respond, but at the same time, with the proviso that when Mr. Story comes back, we will then give him that opportunity so that in your response, you are able then to engage with all the three presentations. Over to you. You are muted, Chair.
Thank you, Chairperson, and once again, good morning to you, morning to the members of the committee, and all protocol observed. I'm quickly trying to share my presentation.
Our apology, I suspect you were still preparing yourself to be the next one to present.
Correct, Chair. Can I get confirmation on whether members, Chair, can see the presentation?
Yes, indeed. You can see it. You can proceed.
And I'll take your guidance here, Chair. So I'm going to skip the responses that we prepared for CASA, and I'll start with responding to the presentations that were done by both Mr. Reni van Zyl and Mr. Herman Veldenboer.
Yes. I got that.
And okay, then if there's the understanding, my presentation will start from slide number 5.
Yes, you can proceed.
Okay, thank you, Chair. So with respect to the submission that was made by Mr. Reni van Zyl with respect to changing the name from director to the commissioner. Here, our response is that this is just the name. This is just the name that is being changed from director to commissioner of civil aviation, and the change is meant to address the confusion that currently exists with the title of director. And normally we all know that in government structures, director is referred to as the first level of SMS in the government department. So we are actually trying to address that confusion here, and the powers, functions, and responsibilities will remain unchanged. And we are also stressing that the change will also not have any effect on any of the decisions that have been taken by the director, or any decisions that are about to be made by the director, and it also has no bearing on the validity of any of the documents, be it the licenses, the certificates, permission, or any authorization or no approval. So therefore, there will be no, in addition, there will be no financial bearing associated with the change of name. And further, the change of name, we are here also stressing that the name Commissioner of Civil Aviation is actually the title that was used before the Act was amended in 2009, and it will not disadvantage the incumbent to the position any better than when the title was that of a director. So then I'm moving to the next submission that was actually made. And the next submission is with regard to the disagreement with respect to what we articulated relating to the establishment of the Aviation Safety Investigation Board that we normally call ASIB. And here our response is that with regard to the establishment of ASIB, our initial position and the most ideal position will have been to create a complete agency. And as you may be aware, Chair, this is what we actually provided for in the current act that we are trying to amend now with this process. But however, most of the provisions in the current chapter could not be proclaimed as it could not be operationalized. So the situation proposed by this bill is the most ideal position, taking into consideration our circumstances as the country. And the government has actually now made a policy, and in terms of the government policy, no further agencies should be established, and National Treasury had indicated that it will not allocate funds for us to establish ASIB as an agency.
My apology, Ms. Can you mute your phone?
Ja, ek sê jy kan maar terugkom as jy wil, hoor.
Mr. Herman.
Ek dankie vir die opwaardeerde omsetting.
Herman.
Okay.
Herman, you are disrupting our meeting now.
Stel vir Herman ook, anders moet ek môreoggend dit kyk, weet jy.
Thank you. My apology, Mr. Chair.
Thank you, Chair. And as I've just indicated, that it's a government policy that no further agencies will be established, and this was further affirmed by the National Treasury stance that they will actually not allocate any funding for the establishment of ASIB as an agency. And therefore, what we have now articulated in the bill in terms of establishing ASIB, we are actually trying to come up with an alternative way, considering the current circumstances in the country with respect to coming up with an ASIB structure. And this position has been discussed with the KO, and to a certain extent, the organization is satisfied with this arrangement. So then moving to the next submission that was done. Okay, the next submission that was done relates to the proposal that we must use similar wording as the ones that are used in section 71 that actually relates to the establishment of the Civil Aviation Authority, and there's further articulation there to the jurisdiction person. And our response to the submission is that based on the explanation that I've just provided with regard to the government policy stance relating to the establishment of agencies, a similar wording for the establishment, a similar wording can therefore not be applied in this case, because ASIP will not be a standalone agency, and it will therefore not have any human resource capabilities that are similar to our CAA. Then moving on to the next submission, where they were actually saying that it is not clear on how the bill will deal with the transportation of armed Air Force and SAPS aircraft. And we are actually here saying that this is actually catered for in the bill, and with respect to exemptions that are applicable in the Act with respect to transportation on behalf of states, and the exemptions are clearly articulated in the bill with respect to the Armament Corporation of South Africa Limited Act and the Defense Act. And in addition, should a need arise or should a need be established for further exemption with respect to transportation of armed equipment, the minister will continue to consult with the relevant ministers to provide any further exemptions if the feeling is that what is actually contained in the applicable section in the bill is actually not sufficient for the purposes of transporting arms. Then I'm now moving to the submission that was actually made. I'll continue with the submission made by Mr. Reni van Zyl, and from here on, the submission made was also supported by Mr. Herman Velden-Boom in his presentation, Chair. And the first one relates to, did I skip? No, apologies, sir. And the first one relates to the where they are actually indicating that there's a confusion with the way we are using the definitions with respect to aerodrome, airport, and heliport. And our response is that the definition of aerodrome as defined, the definition of aerodrome is actually defined in Annex 14 to the Chicago Convention, and within the South Africa context, an aerodrome